Story: should politicians who are convicted in criminal cases be barred from life from entering the electoral battle, from contesting elections? The central government thinks yes, it would be too harsh if they are banned for life, and that the current period of disqualification, which is 6 years, you cannot contest elections for 6 years after you've served out your time, that the central government feels is enough of a deterrent. In an affidavit filed in response to a petition, the union government said that deciding the period of disqualification is solely within the domain of Parliament. They've also added that the term of disqualification was decided by the House considering the principles of proportionality and reasonability.
का चित्ता का भाव इस कदर गिर चुका है कि इनको ये बात का भी इल्म नहीं कि किस पर कौन से संगीन मामले चल रहे हैं।
तो अभी नरेंद्र मोदी जी की सरकार इस बात को तय करे और वह ये डिसाइड करे कि क्या टाइम बाउंड होगा, उसको सुनिश्चित होना चाहिए सरकार की ओर से। सुप्रीम कोर्ट ने अपना ऑब्जर्वेशन दे दिया है इस पर।
The judgment of the Honorable Supreme Court to uphold the ban till only 6 years and not give a lifetime ban is extremely welcome and fair.
All right, let's try and get some perspective on this. Mr. Aman Lekhi, senior advocate of the Supreme Court, former ASG, is now joining us. Mr. Lekhi, so if you look at global examples, in Australia, anyone who's convicted for a year or more stands disqualified from contesting elections for life. UK, you're barred from contesting polls if you're imprisoned or even detained. Germany, you're barred if a court disqualifies you from polls. Why should it be different in India? Why shouldn't a person who is convicted of a heinous crime be barred for life from contesting elections?
Absolutely not, Rasa. They should actually be barred. But I personally feel that this is at best very interesting news considering our political situation, and essentially something like a pie in the sky. And I'll tell you why. One, this law which has to be passed has to be passed by the politicians. So I don't see any of the politicians, whatever they may say on this news channel, ever passing a law which in fact perpetually bar them. Two, presuming a law is passed considering our judicial system, the finality of the conviction will have to wait till eternity, because it's not as if at the threshold the conviction would be final, because there can be a stay, the proceeding will in fact prolong, and so that will in some way affect. Three, presuming the law is made, considering the history which we have, they are proxies. Like we've had proxies in the south, we've had proxies in the east. You have a politician who's barred, the wife comes in, some nominee comes in, so the bar is actually a non-starter altogether. So I personally feel that the most effective way here has to be a public rebuke, because as they contest elections, and as far as the people are concerned, in fact, the people should be more resolute that we have this information, because it's obligatory that we get to know what is actually a criminal case against the others. So the onus lies on us to make sure that people like them are not actually elected. Here, I feel the Supreme Court also missed a chance, because this was an issue which the Supreme Court ought to have grappled with, and the interpretation was purely literal and something which, in fact, should not actually have been part of the verdict, became actually the law, which has long-term consequences which are necessarily adverse. That said, you actually put examples of other countries where it happens. I personally think it will be welcome. It is welcome. Why? Not because of any other reason, just a threat. Unfortunately, in the system which we have today, even the threat of a adverse consequence to something which is in some way severe in any way is absent altogether. So that brings a culture of impunity in whatever we do. So a law like this, for all its pitfalls, can always be a perpetual threat where these politicians are concerned, but I have absolutely no hope from any one of them.
But very quickly, Mr. Lekhi, isn't there an inherent legal double standard here? For example, if you have to apply to be a government employee, a Sarkari employee, even if it's a Class C, Class D employee, if you have a conviction against your name, then you're disqualified. You're not allowed to apply in the first place. But to be an MLA or an MP, that's not a disqualification.
Yeah, because these politicians are considered themselves above the law, and the law is what the politicians devise. So as the law is what the politicians devise, and they consider themselves beyond the law. So this is a meta-legal principle which is there, in which you say the right and wrong is going to be decided by what the politicians say. So what our understanding of right and wrong will be defined by what they actually say. And because this is defined by them as not to be a wrong, so it's not a wrong at all. That's the way in which it progress.
We'll leave it at that. Thank you very much, Mr. Lekhi, for joining us and explaining that to our viewers. The lawmakers create the law and then they sit in judgment of the law, because the judges can't they can only interpret the law, they can't make the law. It's up to the politicians who've made the law, and clearly it's a nice old boys club where they can say, okay, let's cap it off at 6 years. But